Welcome back to the second segment of this law session on public law answering exam questions. And before the break, I was giving you some general advice. In this part, of course, we're going to be a little bit more specific. Now, before we get into specifics, I do want to remind you that remember, you are not reading for your exam. If you were reading for your exam, you'd probably get a first, because the hours and hours that you've spent reading, you would undoubtedly be able to say to the examiner, right, I'm ready for you. But you're not reading for your exam, you're writing for it. So, if you consider that the amount of time you spend reading, you spend an equal amount of time writing, the practice would just be extraordinary. So what I'm going to suggest to you is, in as much that your time that you're taking to read, you spend as much time practicing to write exam questions, because practice makes perfect. All right. I promised you that we would consider a question in public law relating to constitutions, and what we will consider, of course, is question 2, which was posed on the University of London LLB Programs 2011 Public Examination paper. And the question says, discuss the case for and against a written constitution for the United Kingdom. So that's the question. Discuss the case for and against a written constitution for the United Kingdom. Now, simple enough. The unfortunate thing, of course, is that sometimes students see the word constitution, the word United Kingdom, and they go off at a tangent and talk about various other things. Parliamentary sovereignty, separation of powers, the history, and then they say, oh no, I ran out of time. Well, like I said in the first segment, you shouldn't run out of time. You shouldn't run out of time because you should know what 35 minutes of your time looks like, at most what 45 minutes look like. So you should practice. Now then, it asks a specific question, or rather, it sets you a specific task. It tells you to discuss. It tells you to consider the case for. It asks you to consider the case against a written constitution. Bear in mind the emphasis on the word written, which we'll get back to, for the United Kingdom. The point is, please answer that question. Don't answer, oh, it's a constitution, unwritten constitution question. Discuss the case for and against. Use synonyms. The advantages of and disadvantages of. The merits of and the demerits of. You've got to break it down to yourselves to work out what they're asking me. And then now, you go into your writing. So, imagining the question then, and looking at it, it is a broad question, which is pretty much asking you about the advantages and disadvantages, the good points, the bad points of a written constitution. Now, this, of course, means that it comes from those broad questions which tend to lend themselves very easily to many different approaches. Now, the examiner is not looking for clones. The examiner is not looking for a canned essay, meaning an essay that your tutor gave to you and you're regurgitating it. That's not what he's looking for. He wants you to think about the question, and then from what you know, the knowledge you have, what from that knowledge is a good point, what from that knowledge is a bad point. So that's why you can get 10 law students going to an exam, same law, and their paper is different. It's because you are writing from your style, but you're using the rules of legal writing. So do consider the path you're going to take and consider the definitions that will be required. At the very least, you would need to define the word constitution. And then, of course, you would need to at least briefly explain the different types of constitutions that you know about. Notice I say briefly, because the danger with law students is they start right. A constitution is a set of rules, and they go, a constitution can be written or unwritten, federal, unitary, rigid, flexible, monarchical, republican. And then they spend time explaining what is a written constitution, what's an unwritten constitution, what does federal mean. And they go through all of that, and they've taken 40 minutes. But they haven't answered the question. They haven't put forward the case for. They haven't put forward the case against. They've just written generally. Now, the biggest blunder, as I say, is to start discussing just a general constitutional law answer and to throw everything in that you know. On the one hand, every type of constitution and definitions. At worst, throwing in a little bit of separation of powers, a little bit of parliamentary sovereignty, a little bit of rule of law, or worse still, imagine that it is a rule of law question and answer that. Look at the question. If you did write, for example, on any of these obscure topics, which has nothing to do with the question, you would most certainly fail. And I don't preach failure. Now, the most obvious thing you will pick up on in the statement from the examiner is the word written. It sticks out like a sore thumb. If you know anything about constitutions, the fact is that the word written should be going off like red flags in your head. Now, what you know about English public law, the term is a bit of a misnomer, and the correct terminology, of course, is uncodified. So your writing should make much of that, and you can use that as your kind of hook to narrow down what is clearly a very broad question. Now, your first two paragraphs should give some indication to the examiner what your view is, and also for you to flag up that you know this area. Most essays are won or lost in those two first paragraphs because the examiner sees if you're focusing on the question and if you know the area of law, rather than starting back to saying, when one considers the Norman conquest of 1066, where are we going with this? And it's not till we get to paragraph 5 we see that, oh, you're actually talking about the Constitution and its uncodified status. No, grasp the question by the scruff of the neck and deal with it. The saying that first impression counts cannot be underestimated. So don't waffle. In the first and second paragraphs, make a start at answering the question. As I said in the first segment, when you're approaching an essay question, you should set a path and give definitions. So a good start may be something that looks like this. Something along the lines of your writing example. The statement broadly suggests that the UK does not have a written constitution. Arguably, this statement lacks clarity, as a more accurate description of the constitutional framework in the UK is that it rests on an uncodified system. Rather than speaking of unwritten, therefore, the correct term would be uncodified. That said, however, there are various arguments in respect of the advantages and disadvantages of having a codified constitution, with the apparently stronger arguments favoring a codified constitution. Straight away, I have corrected the examiner as to what the statement should be, because as I say, the statement might be slightly inaccurate. And then, of course, I've shown him my path where I'm going, which is that I am seeking to say that there are stronger arguments for codification. I would then, of course, suggest to you that you set out some definition of a constitution and refine your discussion by drawing comparisons with the UK's uncodified framework and a country that has a codified constitution. So, for example, the USA or Canada, or even if you're doing your LLB outside of the UK, your own country, if it has a codified constitution. So, for example, if the suggestion I gave earlier was your first paragraph and you've set it up and it showed your path, then your second paragraph, which would then lead you in defining some of the things that have been set out in the statement, could go something like this. In its broad sense, a constitution is a body of rules regulating the way institutions within an organization operates. However, as it relates to a state, a constitution organizes, distributes, and regulates state power. It sets out the structure of the state, the majority of state institutions, and the principles governing their relations with each other and with the state's citizens. A more narrow definition is that a constitution is a single document providing a basic framework for a state's system of governance, defining the relationship between the state and its citizens and between the institutions of the state themselves. The statement appears to focus on the narrow meaning of the Constitution, and as such, substituting the word unwritten with uncodified, a case for and against a codified Constitution will be discussed. That would be how I would like my second paragraph, for example, to sound. I have now defined Constitution. I've flagged up the broad and the narrow definitions. It would then be left to me now to push forward and to say, based on the path I'm going to take here, that I'm looking at a case for and against a codified Constitution, then I would of course discuss it. Now, your knowledge of this here would then have to be displayed in presenting the arguments for and against. You could of course discuss the type of statutes that have constitutional significance and the proliferation of statutes in the last 10 years or so of constitutional significance as well. So you could of course mention these briefly in your discussion and say why you have mentioned them. That is to say that there has been extensive constitutional reform which has been undertaken. So for example, we see that since 1997, we have had the Human Rights Act, the House of Lords Act 99, reform of the electoral system by virtue of the Political Parties Elections and Referendums Act in 2000. We've also had another Political Parties and Elections Act in 2009, the CRA in 2005, as well as the Constitutional Reform and Governance Act 2010 and some Parliaments Act in 2011. Now, you could use these to point out that there is a substantial amount of written constitutional law by virtue of these statutes. You could then look at the disadvantages and look at the fact that when you look at the volume, this may go against saying that it should remain as it is and look rather for something singly codified. Now, the difficulties in drafting a constitution for the UK, of course, it would need to be discussed in some depth, because if you consider it, how would it stand? What would be the role of it? What would be the basis on which it comes in? How would constitutional conventions be affected? All of these would have to be considered in your answer. Equally, you'd have to look at the implications of a written constitutions, and then you would have to consider it and look at it as to whether or not it would be something rigid. You could also illustrate your point, again, drawing on the codified constitution in other jurisdictions in order to look at an evaluation of the advantages and disadvantages in respect of, say, constitutional rigidity, looking at, for example, should there be a trade-off in it being rigidly codified, or is it that it does help as it currently stands in its inflexible state? Now, the major problem for a question like this is for students to literally lose their minds, throw in everything they can think possible in relation to the Constitution, and so it would not be sufficient, for example, to simply set out a description of the Constitution, because this would not show knowledge. Structure your answer. You should have, by say paragraph 3, given an indication as to your arguments for your position. You should set out by say paragraph 5 the arguments that go against the position in relation to that you're discussing. Now, I'm from the school of thought that you should make submissions in favor of a position, although you will get examiners who say you don't have to choose a side, rather you simply give the arguments for and against and conclude. I always feel that it makes your discussion clearer, but this is my personal viewpoint. If you lean in favor of a position because your discussion then seems to have a better analysis and focus, but that is my personal view. Now, that is my suggestion on your approach to answering that question. We will now take a short break, and on my return, we will consider another question. Basically, we will look at sovereignty. If you are signed up to our premium service, then contact us to request a copy of a sample answer to this question that I've just discussed, which was written under timed conditions of 35 minutes or less.